Hi, folks. This is Attorney Kip from Malek, and today I'm going to be talking about something that might come up with you. And usually, I'm going over these cases that might have relevance to my clients, or maybe you, or you've run into it. But this is pre-employment tests. What happens if you get injured during a pre-employment test? What are the implications? The case that this comes from is called Dotson v. Conrad. It's an appeals case. And so, what ended up happening in this case is this individual was applying for a position as a police officer. And as part of the application process, he was required to run through an obstacle course and perform various tasks. And at one point, he went through a window and he ends up fracturing his leg. So, he gets ostensibly it's happening during what he thinks is work activity. So, he wants to file a workers' comp claim. So, if you review this case, and if I could find the link to it, I'll post it in the comments, and you can read the case yourself. Otherwise, the case, or the court in this case, reviews a number of other cases from different jurisdictions, and the observations, or the commentary that they made, was one: if comp were awarded to an applicant during a pre-employment physical agility test, every person who makes an application to an employer, fills out an application and takes any kind of test, is an employee. That's the implication. Which, I don't know. I think it's kind of, if it was just that, I think that'd be kind of extreme. Particularly the type of test that this guy was undertaking. It was kind of a physical thing that he had to do. But they go on to a little bit further. And some other factors that must be, or needs to be considered, must be considered. So one thing they say, a claimant must be under a contract for hire in order to be considered an employee for an injury sustained during a pre-employment test. And you kind of might argue, well, if it's in pre-employment test, how would you be under a contract for hire? But nevertheless, the example they give is this lady is hired to start on June 22nd, 1992, and she is injured during a pre-employment physical. How do you get injured during physical? I have no idea. I don't know the facts of that. I'd be interested. But bottom line is, it happened a few days before, and the court in that case was like, nah, no claim. So they go back to the factors in this case, the police officer issue, or the pre-police officer, and the conclusions they make are, the police officer was not yet hired. He had not even received a conditional offer of employment. So maybe if he was hired and he had received a conditional offer, maybe that would lean him more towards being an employee. And then the other thing is, he was not performing a service for the city. The city received no benefit. So again, maybe if he was performing a service for the city and the city received a benefit, maybe that would make him an employee versus non-employee. So nevertheless, they looked at those things: not yet hired, didn't get a conditional offer, not performing a service and for the city, and the city received no benefit, and then concluded he's not an employee, not entitled to participate in the workers' comp fund. So we're always looking at, other applications, or how's the Industrial Commission applied this case. So you could look, and I think I've posted the link, and I'll post the link again. But if you go to the Industrial Commission's website, you could read all the commission orders. And commission orders are kind of like precedent. It's kind of like the way that the full commission interprets case law, and it's kind of precedent for the Industrial Commission. So precedent means it's like the thing that informs the decision, subsequent decisions from that case. So if, like, in the highest precedent in the United States would be the Ohio, or the United States Supreme Court, and then you go the state Supreme Courts, the appeals courts, etc. So at the Industrial Commission, the thing that holds precedent for them, besides all these other Supreme Court and all this stuff, would be full commission orders. So they're helpful to see how the Industrial Commission interprets difficult and complicated factual situations. So nevertheless, apparently this claimant had filed, there's a full commission order from January 5th, 2016, and apparently the claimant had filled it out in an application for employment on July 6th, 2015. They were invited, and I think it was some kind of lumberyard or factory of some sort, and they were invited to come in to perform an assessment. So that'd be like a pre-employment test on July 7th, 2015. So the thing that they're asked to do as part of this pre-employment assessment was to observe a worker using a bandsaw to cut a pallet in two. So they observed the worker cutting the pallet in two with the bandsaw. Maybe they looked at it a few times, and then the employer's like, "Okay, you watched them. Now let demonstrate to us that you can do this task." So it's horrible luck for this individual, but um, the first cut of the operation of this bandsaw, when they stepped up to do this thing, they managed to lacerate and fracture their finger. So during their pre-employment assessment, they end up getting a fairly significant injury. And it seemed, you would think, okay, it's a work injury. So but the IC found, again, relying on that Dotson case with the police officer, found there was no contract of employment between the parties. So again, you got to look, maybe if there was, maybe if the individual was hired, maybe that would put him more as an employee kind of situation. And then no benefit was provided to the employer that was sufficient to create a contract of employment. So again, maybe through your pre-employment test, if you're providing some kind of benefit for the employer, they could look at it and they could determine, okay, maybe that weighs more towards this person being an employee versus non-employee. So nevertheless, they found that the claimant was not in service to the employer, not an employee, and then that claim was disallowed. So apparently the claim was allowed at the DHO or SHO, I guess it would be the SHO, and then the employer appealed, goes to the full commission. Full commission reverses the decision of the staff hearing officer's decision. So I don't know. It's kind of sucks for the claimant in this situation, but yeah, that's kind of what you got to look out for. I mean, all these factual situations that injured workers or workers get involved in, they're all kind of complicated. There's all little twists and turns. So as I always say at all these videos, don't do this workers' comp stuff on your own. Get a workers' comp attorney involved. At the very least, consult with a workers' comp attorney. Whether you call our office, run your fact pattern by us, or you call any number of other workers' comp attorneys that operate in Ohio. Do a search on Google. Ask your coworkers, ask your friends, ask for family, but talk to and frankly get a workers' comp attorney involved to represent you for your workers' comp claim. It's going to pay dividends. I strongly recommend you do so. Again, you've been listening to Attorney Kip, Malek and Malek. If you have any questions, comments, etc., leave them in the comments section. Otherwise, you could email me. You could call my office. Run your fact pattern by me. If I can help you, I will. If I could send you to another direction, I'll do that as well. So I appreciate you listening to this video, and hopefully it provides some useful information for you. Thank you. Bye.